Hey Bay Area! Welcome to another episode of Ask Me Anything with me, Yaasha Sabba, and my cohort, Jasmine. We're both upstairs, we're working, or hardly working, you decide. But we're gonna answer your questions today. So, question number 1. I was married for 21 years and have been separated for the past 3 years. My husband recently passed away and didn't have a will, and our 2 oldest children are just taking whatever they want from the house without even asking me what I want. This is actually very typical of what we see people doing. We had a watch business, making time, telling time, and we have amassed quite a few watches over the years, and the kids are now in possession of the watches and they have no idea how much they are worth. And I'm entitled to the watch collection since we were business partners. Also, I have our youngest son and I wanted to have a car, but my son is insisting that he's going to get it. Oh, you both want the car. I see. Please help. I'm located in California. Okay, first steps first. Even though you're separated, if you're legally still married, you still live in a community property marital estate. What does that mean? Everything you and your husband own during marriage and acquire during marriage is 50-50. So your business, you and your husband both had created the business together. You are an owner of that business. The question I have with your business, your watch business in particular, is did you form an LLC? Did you form an entity? Or was it a sole proprietorship between you and your husband? These will tell us what next steps we can take on getting those watches back from your kids. However, because your husband did not have a will, all of his share of the estate, all of his assets, anything that is owned in just his name alone, not jointly owned by you, so the house, for instance, if you guys are co-tenants of the house will automatically go to you because that's the law. But if there's any bank accounts that were just in your husband's name alone, or if your husband had any businesses of his own, that all needs to go through probate. And your next step is opening up a probate for your husband. This is the fastest and strongest way of getting your children's attention to let them know that what they're doing is wrong. It's actually very typical that when a loved one passes away, all the family members kind of converge together. They go into the home and they say, oh, okay, these family heirlooms or these personal assets of mom and dad, what do we want to have? And there's nothing really bad about that. It's something that a lot of people do. They have memories of, oh, that's mom's, that's grandma's wearing, that mom was wearing. I want to have it because I want to remember my mother by that, for example. But here, it sounds like your sons, they want these really nice, expensive watches that don't belong to them, but belong to the business. So I would immediately notify your sons that, hey, you guys, just letting you know, that is inventory of the business. If you don't return them, I'm going to have to take legal action. But outside of that, everything else, it's just simply how much did your husband have on his side of the estate? If he had more than $166,000 worth of assets, and it sounds like the watches are pretty expensive, and that means the business is expensive, then yeah, he has to go through a full probate, and you've got to get that started. Don't just sit around waiting. On the other hand, if he had less than that, you don't have to go to court, you don't have to go to probate, but you still do need to take some legal action on how to handle the remainder of his affairs, closing his credit cards, paying his final taxes, closing any bank accounts, and then making sure a portion of that does go to you. Now, because he didn't have a will, under California's rule of intestacy laws, this is the laws that the government has for you if you don't do any planning whatsoever, a portion of his estate goes to the surviving spouse, and even though you're separated, you're not legally separated or divorced yet, so you're still the surviving spouse, and then the other portion goes to the kids. How that's all split, it's supposed to be split equally, and if it can't be split equally, you either get an agreement from other family members on how to deal with it, or you sell everything and give the cash to everyone equally. So it's not necessarily a pretty process. You do have a little bit of work ahead of you, and I suggest you either reach out to me or another attorney that can help you with this process, or good luck doing it on your own. Send your questions to us so we can tell you what they look like, okay? Next question. My mother wants to protect the equity in her home from her debts when she passes. Okay, we live with her and take care of her. What's the best way to keep the house when she dies? The easiest way is have your mom create a will, but that means the house is going into probate. And I think probate, what we do when your house goes into the court process, take the fair market value of the home and add on 5%. That is how much money it will cost to get the house in probate and retitled to you. So basically in and out of court, 5%. If you can't afford to pay that, or if your mother's estate doesn't have the cash to pay that fee, that's the court fees, attorney's fees, appraiser's fees, everything, roughly 5% of the fair market value, even if you don't own the home outright and completely, it's got a mortgage, California doesn't care. We take the fair market value of the home, and that is how much it will cost to get in and out of probate. And if you don't have that money, the home has to be sold. So if you want to avoid probate, which is what I recommend everybody does, we shouldn't have to go to probate at all. Then you need to either create a trust, put the home in the trust, and that way it avoids probate completely and goes automatically to the beneficiaries. So your mom would need to create a trust, put the home in the trust, and name you as the beneficiary. Or a little bit cheaper, a little more riskier, your mother can file a transfer on death deed. Now, it's Christmas and COVID, and we are all at home, not really having any holiday affairs, so much so, right? So keep in mind, transfer on death deeds in California, the law expires December 31st. So if you really want to do something like that, record a transfer on death deed. What is that? It's like naming a beneficiary for your home, like you would name a beneficiary on a retirement account. You record this deed, you're not transferring the home to anyone, you're recording a deed that says, upon my death, I want this property to go to these people. And you have to name these people. You can't name a trust, an estate, or anything. It has to be individuals. So it's a little restrictive and a little harder to do. But when your mom passes away, the house is automatically titled over to you. And the only time you can record a deed like this is this year, and this year is almost over. So if that's something you want to do, you need to act fast. You can reach out to me, info@skyunlimited.law, or just give us a call or send me a message on Facebook. I'm everywhere, right? But that's something you do have to act fast on if she wants to execute something like that. That won't be an option next year. The only option you will have is write a will naming you as the beneficiary, your mom's will, or create a trust. Transfer on death deeds, I guess this year was the year they were supposed to extend that law, but because of COVID, our legislature is a little busy trying to make money.